judiciary bail and bond policy guidelines, together with several decisions of superior courts in the land, that is the Court of Appeal and the High Court. And Your Honor, that the list provided in the judiciary bail and bond policy guidelines is not exhaustive. But without going to the particular facts which my learned senior Mr. Kula is following me to talk about, that list includes as compelling reasons the likelihood of interference with witnesses, the likelihood to interfere with ongoing investigations, and the likelihood to interfere with exhibits. In concluding on the legal issues, the primary purpose of bond is to ensure that an integrity of the trial before you. Protection of the integrity of the trial before you. So that, Your Honor, even where it is shown that an accused person shall turn up for trial, if released on bail, where releasing an accused person on bail will prejudice the integrity of the trial. Where releasing an accused person on bail, even where it is shown that they will attend trial, where releasing them on bail will prejudice the trial and therefore the integrity of the trial. This court has a reason, a compelling reason to deny them bail. And Your Honor, a likelihood to interfere with witnesses, exhibits, or ongoing investigations is a high likelihood of interference with the integrity of a trial. That is our submission. Allow me to say the last thing on Section 8, subsection 2 of the Magistrates Court Act. Section 8, subsection 2 of the Magistrates Court Act deals with the court's jurisdiction, I mean subordinate court's jurisdiction, to enforce Bill of Rights or questions of interpretation relating to Bill of Rights. That jurisdiction is limited to Article 25A and B of the Constitution. The rights under Article 25A and B of the Constitution it is a clear statutory statement that this court's power to enforce Bill of Rights is limited to the rights under Article 25A and B and nothing more. So that, Your Honor, reference to constitutional provisions as regards Article 49 on bail can only be made in respect of 25A and B. Anything outside of that is outside your jurisdiction, and where you have no jurisdiction, you pen down on those questions of constitutional interpretation if raised. I am honored to appear before you. I thank you and invite my learned senior, Mr. Akula.
And on your file an affidavit sworn on 19th May 2025 by Mr. Robert Brown. 19th of May 2025, this morning. Thank you, yesterday, Your Honor.
That is very good.
Thanks for your 19. You filed this morning. Yes, Your Honor. It is sworn by Robert Brown. Robert Brown, an EACC forensic examiner. There are the factual reasons or grounds to reject bail are deponed from paragraph 1 to paragraph 12. However, I will cluster them into three, 1 to paragraph 12. And however, I will cluster them into 3 compelling reasons. The first one, interference with witnesses. The second one, public safety. And lastly, the severity of the offense. For the first compelling reason, my Lord, we submit that subject to this case, there are other ongoing investigations. Which at paragraph 3 and 4 found that paragraph 3 and paragraph 4 of the affidavit confirm that the accused person, through his agents, attacked EACC and LPS officers in lawful exercise of their duties. This has been reported and is captured under annexure number R38. At Kitale Police Station. R38. PR38, annexure PR38. Your Honor, we have annexed 4 photographs of security vehicles.
With your kind permission, I wish to raise an objection. An objection, Your Honor, is founded on Section 106B of the Evidence Act.
That is your name?
Willis Otieno, counsel for the first accused. Section 106.
Yes,
Section 106B
on electronic evidence.
on electronic evidence.
You get your time.
No, I wanted to raise an objection because it's time to refer to it.
You get your time, let him continue.
Also, we have a next
I want to conclude the direction first. Mr. Abdullah, you can continue.
Yes, Your Honor. We have next a series of photographs marked as RR1 to RR37.
One, two, R,
37.
37.
Your Honor, those photographs depict vehicles belonging to EACC, National Police Service, that were vandalized at the residence of the accused person. Yesterday, when the officers were executing the lawful mandate.
Executing?
The lawful mandate. That is, doing a search pursuant to miscellaneous application E716 of 2025.
Come again. Miscellaneous application number
E716
E716.
of 2025. That is detailed in paragraph number 4. Do not photographs RR3 to RR10. RR3 to RR10. They depict motor vehicle KCH 046T.
Come again.
046T. After it had been vandalized. When our photographs are 11 and 12, depict KCD 628X. Photograph R11 KBU 734Y. And photographs for 541U, ACF 541U. At paragraph 7 and paragraph 8, the officer depots.
Sorry?
At paragraph 7 and paragraph 8, Mr. Rono depots in these vehicles. Important documents were taken. Now we take judicial notice of the position of the first accused. The witnesses in this case, Your Honor, upon disclosure, are his subordinates. People employed under his government. What is the test of interfering with witnesses? It is not beyond reasonable doubt. The test is just a reasonable prospect that the accused may tamper with the witnesses.
The test is?
A reasonable prospect that the accused person will tamper with the witnesses or the evidence.
Perhaps, and I'm aware of the directions you've given for the diaspora. Perhaps we need your guidance whether counsel can go outside the content of his affidavits and claim to bring averments that are not contained in the affidavits, because that will prejudice us in terms of our response. Because there is no averment in the affidavit to that effect that the proposed witnesses are the subordinates of the government.
I'll give a guidance again. Wherever you pick along the way from both submissions, kindly bundle them together. Once you rise, I expect that you address all the issues in one sweep.
I'm wondering.
But let me record you first. Mr. Akula, give this some Please record this objection. Everyone,
I will repeat your honor.
How long more? I thought we were going to take 3 minutes. Now we are going to we sit here the whole day. Just off the cuff. How long more?
Around 10 minutes. 10 minutes. Just summarize this.
10 minutes. Continue, Mr.
Yes, sir. I will repeat
You
that.
have 10 minutes.
We are submitting that once disclosure is done, the witnesses will be calling our officers from the first accused government. Those are disabilities.